Was your verdict influenced in any way by the communications of the clerk of court in this case?
Yes, ma'am.
And how was it?
And of course, that's convicted killer Alex Murdaugh now back in court wanting a new trial as one juror says the county clerk influenced her verdict. We understand, we're going to take you live inside of the courtroom now. A verdict actually might be read if we are able to take that. It's been just under a year since the jury found Murdaugh guilty for the murders of his wife and son. And while the evidence was stacked against Murdaugh and his team, they claimed that the jury only came in to a conclusion because of the statements from the Colleton County Clerk of Court. We're going to take you inside to be able to listen now.
Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after-discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by clerk of court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict Defendant Murdaugh. The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The Clerk of Court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders.
All right, we're just listening there
I
to the
will
presiding
finalize
judge in
this
this
record.
case, former Chief Justice Jean Toll, denying a new trial, but giving us a lot of information. I'm going to bring in Collie Frodes to this conversation. So glad you are here at this very moment to explain all this to us, because I think one of the biggest lines that Chief Justice Toll said was that Miss Hill was attracted by the siren call of celebrity.
It sounded like for a second there that she was going to grant a new trial.
I mean, we were all on the edge of our seat. Everyone, I mean, if you're watching this, it's kind of like a ping pong match. You're like, okay, she's going that way. She laid out the standard, which wasn't improper content made. And she believed that, yes, there was improper comment made and that Becky Hill had ulterior motives. And so we're like, okay, check one. The second prong is there. Did it influence the jurors? And that's the portion where I didn't see it going that way. I listened to the questions that they had today for the juror that said, listen, I heard the comments. I thought I was pressured. I felt that I was pressured. They were so close to saying I was influenced.
Yes.
Like right there. And the judge even hammered home and when they were asking the questions. Did you feel pressured or did you feel influenced? Or did it influence your decision? That back and forth question is what decided this right there, right in that moment of her question.
But Khalif, one of the big things that happened today is we found out that there were jurors who are watching testimony today back on court TV. So now you're watching testimony before you get on the stand.
Well, what we can say is this was a cluster. This whole county has been a cluster throughout this entire process. The only reason that we're having a new hearing to decide if he can have a new trial was because there was misconduct. And I've been in that situation. I clerked for a judge for 2 years in Michigan. In the process for bringing a jury in and ensuring that they are secluded and ensuring that no one can touch them, ensuring that their cell phones are not on them, ensuring that they get them back at the end of the day. That whole process is very serious. I took pride in making sure any staff that assisted me with walking them in the courtroom understood that we don't want to mess this up. This process is extremely important. We're the very beginning of the trial. If I say something to them or bump them, I wouldn't even look at them. I would look the other way because I didn't want to have any interaction with the jurors at all during that process. Let them go in the courtroom, allow them to be sworn in, and let them do their duty. It seemed like misconduct throughout this entire process. And so if I was a hedging person, I was hedging on new trial because even listening to the testimony, it seemed like there was enough.
Well, and it was interesting because the judge, she seemed to disagree with both the juror who said that they were influenced and the clerk of court who said that she was credible and that she didn't influence the jury. She disagreed with both of those.
With both of them. And then what I can say is the part that really confused me is she said she weighed in that portion of her thought process was the amount of strain that it would put on the state of South Carolina for having another trial. And I don't even know if that's the standard. Like, it doesn't matter if the standard, the two prongs are met, even if it costs the state of South Carolina $1 million to do a whole nother trial, you have to have another trial. And so I don't know if that portion should be added to her order because she said it was, but in her thought process, and it was. So if I'm his attorneys, if there is a route to appeal, I'm looking to appeal just because of that, because she added an additional layer of a standard that's not there.
A major blow in the case for Alex Murdaugh. He is not going to be getting a new trial at this point so far in the process. Collie Frodes, thank you so much for your insight. We'll be right back with more news and weather.